Hi, I'm Peter Nicholls, Principal of Apres Legal. Today I'd like to talk to you about director penalty notices, or as they're often called, DPNs. A DPN is issued by the Australian Tax Office to directors of companies where those companies have, for example, failed to pay their GST, PAYG, superannuation guarantee, luxury car tax or wine equalisation tax. Because the fact that the DPN is issued to a director and makes him or her personally liable for those debts, the first piece of advice we would give is, whatever you do, do not ignore the receipt of DPNs. There are two sorts of DPNs. There's a lockdown DPN and a non-lockdown DPN. Let's talk about the lockdown DPN first. In that particular circumstance, the company may have missed putting in its BAS on time or not paid some significant amounts due to the tax department. The director, on receipt of a lockdown DPN, is liable for that debt. There are very few defences available to change that situation in favour of the director. So the only way to really overcome the lockdown DPN in reality is to actually have that debt paid. You may be able to arrange a payment plan through the ATO, but again, that will be dependent on what the history of the actual relationship is between the company and the ATO. The other sort of DPN is the non-lockdown DPN. In that particular case, the director has got 21 days to actually do something about the DPN from the date of the issue of the DPN by the ATO. And when I say has 21 days to do something about it, they can, for instance, in the case of the lockdown DPN, they can pay the debt, or again, arrange for a payment plan to be put in place by the ATO. In that particular case, though, we need to be very careful. The director needs to be quite confident that the company can actually trade through this difficult period, because if you arrange a payment plan, then the actual debt becomes the director's debt from that point on. And if the company fails, then what will happen then is the director will be personally liable for that outstanding DPN debt. The other way to actually remit the debt back to the company is to appoint a voluntary administrator or a liquidator, or if appropriate, a small business restructuring practitioner. If, in that particular case, if those appointments are made, then the debt is remitted back to the company and it's no longer becomes a debt due by the director. So the takeaway message from this is, if you get a DPN, if you receive a DPN, act quickly. You need to contact your legal advisor and your accountant and get good advice with respect to how you might best handle the receipt of a DPN. We at Apres Legal can assist in these types of matters, so don't hesitate to give us a call, obligation-free, call to start off and to see whether we can assist you with the receipt of this DPN. Of course, today's conversation is very general in nature. The legislation is quite complex, so please don't take this as legal advice, it's general advice. For professional, tailored advice, please call the team at Apres Legal. Thanks for listening.